Okay, dear friends, let me tell you what happened this morning regarding Luigi Mangione. By the way, Mangione means big eater or gluttonous or something. Mangia, one. One always is the opposite of the diminutive, the aggrandizer. In any event, who cares? First, before we begin, let me just say something. He's guilty. Nobody killed this insurance executive but him. This is not like Tyler Robinson. Tyler Robinson, I don't even think did anything. But Mangione is guilty. Nobody else did it. Nobody else. Don't even confuse yourself as to this. Nobody is involved or is in any way involved. He did it. Absolutely. You understand this? Which may make the whole thing seem absurd to many, because now we're talking about the procedure. Yeah, he did it, but did you follow the rules? Did you seize evidence under the Fourth Amendment? Did you have a warrant? Did you do this? So just so that you understand this, it's not who done it. He did it. Absolutely. Which, of course, cracks people up because a lot of people don't understand this. So anyway, so here's where the Luigi Mangione case stands right now after this morning's ruling in Manhattan, as people say. Okay, so what happened? First, New York State Supreme Court Justice Gregory Caro. Now stop right there. In New York State Court, the trial court level is called the Supreme Court. Now, most states, you go like county court, circuit court, municipal court, whatever it is, and then, Supreme Court, not New York. Supreme Court is the state level, the entry level, the trial level. The case nisi prius, unless the first. That's a trial court level. Okay, that's it. So that you understand. So Judge Gregory Caro ruled on Mangione's motions to suppress evidence connected to his arrest in Altoona, Pennsylvania, where this dumbass genius went to a McDonald's with cameras on clouds, and he's sitting there. I mean, the genius. Oh, he's so smart. To a McDonald's? Okay, all right. To each his own. So anyway, he was arrested in Altoona. Now, the ruling was a split decision, meaning the defense won part of the argument, but prosecutors kept some of the most important evidence. That's always a good one. If you're a judge, split it up. Say, well, good news for you here, because sometimes when the judge is a little bit too willing to suppress evidence that could theoretically hurt you, you think, oh, that's good. It's like, wait a minute, what's he really up to? Well, maybe he's trying to help to prevent himself from being reversed on appeal. Judges hate that. So just keep it in mind. Now, what was suppressed? The evidence the jury will not hear in the New York State trial. Remember, there is a concomitant federal case. Right? Like next door, literally, okay? The judge ruled that police conducted an unconstitutional, warrantless search of Mangione's backpack at the McDonald's in Altoona, where he was arrested. Now, because of that, several items are out. You ready? The cell phone he had, okay? A passport, a wallet, a magazine, a computer chip or electronic storage items. The judge said that the initial backpack search violated the Fourth Amendment and rejected the prosecution's exigent circumstances argument. Exigent circumstances is a classic case. I think the case was Peyton years ago. Sometimes when they bust down a door, they're following you, let's say they're chasing after you and you run inside a house, they break the door down, they can't get a warrant, they're following you. Exigent circumstances, meaning exigent or emergency circumstances that make the obtaining of a warrant impractical. Now remember, the Fourth Amendment, all of the Bill of Rights provisions have about 9 million exceptions, right? You need a warrant. Well, unless you arrest somebody, then if you arrest them, then you can search everything and anything about them. Everything. Search incident to an arrest. No need for a warrant. What about a warrant to arrest them? Don't you need a warrant to arrest people? No, unless there's probable cause and it's in open view. What? So there's all kinds of exceptions. So that is I guess a meaningful defense win, because the defense has argued that from the beginning that Altoona police rushed into the search without a warrant, while officers themselves were reportedly debating whether they legally needed one. That's not a good thing. So what evidence can still come in? Now, this is important. This is where the prosecution still has serious firepower. Judge Caro ruled that the other evidence recovered later at the police station is admissible, including the alleged 3D printed murder weapon. Hello! Keep your notebook. I'll explain the notebook. Keep your wallet. Yeah, keep it. Give me the murder weapon. The 3D ghost gun printed. The notebook and journal describe it as a manifesto that basically lays out his intention. That comes in. Additional inventory search evidence obtained after the transport to the police station. Very interesting stuff. Whenever they seize a car, they seize you, then you have, let's say, a suitcase, or you have some kind of thing on you, they later on can go back and they inventory search it for your safety, for your benefit, to find out what they have, so that later on you can't say, hey, where was that diamond ring that was in that car? So it's supposedly for your benefit, Roy. You see, when you are seized, and this is also critical, if you watch, like I do, these great YouTube shows of police arresting these dirtbags for a variety of reasons. But once you are detained and you are in custody, you belong to the police. They can order you out of the car. Everybody knows Pennsylvania against Mims, 1978 or some case. Well, you can get out of the car. They can drag your ass out of the car. I mean, bust the window, reach in, grab you, pull you out of the car. Oh, yeah, because you're in custody. And when you're in custody, then you have search incident to an arrest. Now, custody, I'm not going to go into the weeds here, but custody and detention is not the same as an arrest. To be held in custody, to be held in detention, you are not free to leave. It is a brief restraint on your liberty to allow the police officer to conduct some initial investigation. You are not under arrest. You just need reasonable suspicion to stop people. That's also, you've heard of the Terry stop, Terry against Ohio. That's just to stop you. Probable cause is to arrest somebody. Don't worry about that. I'm just trying to always throw out, whenever you think this is real easy, it's not easy. It's pretty much easy, but things kind of shift. Okay, now we went from the detention to the arrest. And now when you're under arrest, now I can go through your pockets. See, if I stop you at a McDonald's and I say, all right, I think this guy could be the one I'm looking for. Terry says, if you have reasonable suspicion to believe a crime is being committed, was being committed, is about to be committed, you can conduct a brief custodial pat-down. Why? To protect the officer, to make sure he doesn't have a gun. You can just pat down. And then if you feel like, wait a minute, what is this here? What is this? Hey, it looks like this is long, and the descriptions are great. There's something long and hard and metallic. Feels like a receiver. Hey, I think that this feels like a gun. You reach inside. Hey, I was right. It's a gun. That's okay. One time I had a case I had successfully suppressed because the police officer patted down my guy and said, oh, I'm finding packets. This is true. Packets of a powder. Packets of, actually, plastic. He knew they were just dope. He didn't know it was a weapon. So when the judge said, what did you believe made you think that this was a weapon or that could hurt you? He said, it could be poison powder. Everybody laughed. We laughed. Yeah, Yeah, okay, dude. All right, feller. Nice try there, McGarrett. I don't think so. So anyway, so the court in this case accepted the prosecution's argument that the later inventory search at the station house followed standard booking procedures and was legally separate from the improper McDonald search. Okay, so he bifurcated. He divided the two separate instances. So that notebook, by the way, could be devastating for the defense if prosecutors successfully characterize it as motive, ideology, quasi-confessional. Hey, you think this is a confession? Well, says here, I'm going to get this guy, and I hate this guy, and I'm going to get this guy. Okay. Is this your handwriting? Yep. How about that? A manifesto at a murder scene, which basically spells out that which you did. Huh. So prosecutors also still reportedly have surveillance footage, fingerprints, DNA evidence, travel records, the backpack allegedly discarded during the escape, ballistic evidence. So despite this suppression ruling, this is not a crippled prosecution by any means. Now, question you want to ask is, what happened to the terrorism charges in New York? Good question, Sparky. This is one of the biggest developments people missed months ago. Judge Carroll already threw out the top New York terrorism-related murder counts back in September of last year, ruling that prosecutors failed to prove that Mangione intended to, here we go, intimidate, I'm doing the air quotes here, intimidate or coerce the public in the way New York's terrorism statute requires. So the flashy terrorism murder angle is gone in the state case. See, terrorism is to bring about a change, to intimidate a people, to think, the Red Brigade or something. Not just to go after somebody because you don't like his corporate shenanigans. Now, what remains is primarily second-degree murder, weapons charges, forged instrument, fake ID. I love when they tack on this. Fake ID? Yep, tag it on. Jaywalking, pulling the tag off of a pillowcase, whatever. So, and by the way, there is no death penalty in the state of New York anyway, since 2004. So, is a death penalty still on the table? Well, as far as the New York case, no. No, New York does not currently have an enforceable death penalty statute. So even before the terrorism counts were dismissed, execution, was never realistically even happening in the state prosecution in the first place. So the maximum realistic exposure in state court is essentially 25 years to life or life imprisonment, depending on convictions and sentencing structure. Now, the federal case, what about that? Also, no death penalty there. Now, this is the huge federal twist. Federal prosecutors originally tried to make this the first major Trump-era federal death penalty case, the showcase, under renewed DOJ capital punishment policy. Remember Pam Bondi? Remember her? Remember Blondie Bondi? Anyway, Pam had publicly directed prosecutors to seek death. But in January of this year, federal judge Margaret Garnett dismissed the two federal counts that made Mangione death eligible: murder through a use of a firearm and related to firearm offense. The judge ruled that the legal structure that prosecutors used was defective because the underlying stalking theory didn't qualify the way prosecutors claimed. What does that mean? Don't worry about it. Don't worry about it. Then federal prosecutors decided not to appeal that ruling. So, as of today, as of right now, no death penalty in state court, no death penalty in federal court. That chapter is effectively over unless what? Something extraordinary happens. I don't know what happens procedurally. So what charges remain federally? Good question. The federal government still has the following: interstate stalking charges. Now remember something. Federal charges, federal court's different. Sometimes they'll have something, it sounds kind of like chicken shit, like stalking. But they've got like a life, you know, like a life penalty, life felony. My God. So they will have some of the weirdest statutes, but the penalties are huge, okay? So those counts can still carry life imprisonment, okay? Federal prosecutors argue that Mangione crossed state lines and used interstate communications in planning the killing. See, in federal law, they hate that. Just do it in your state. Don't go over there. I can look out my window and I see New Jersey right there. If I get in the Lincoln Tunnel, it's federal. I can do all this mayhem here. Stay in your state. Stay in your state. Don't pick up a phone. Don't mail a letter. Don't say, hey, you know, somebody hears you over there. They hate that interstate stuff. Just stay in your state. So the trial schedule and status, that's a very good question. Very good. Right now, the cases are moving on parallel tracks. The New York State trial, the current expected start is September the 8th of this year. Don't expect it. Expected duration, roughly 6 weeks. Now, the federal trial, current projected federal proceedings, jury screening later in 2026, maybe in the fall. Federal trial after the state case. Now, some reports place the federal openings around October 2026 or January of 2027, depending on scheduling adjustments, plus his federal court. So what is Mangione realistically looking at? Even with the death penalty gone, he's still staring at the possibility of spending the rest of his life in prison. And the defense scored a genuine constitutional win today on the suppression issue, but the prosecution retained, let me say this again, the weapon, the manifesto, major forensic evidence, surveillance evidence. So that means this case is still extremely dangerous for the defense. And the real battlefield now becomes whether the notebook or journal gets interpreted as ideological intent. We don't know what it says, but something tells me this numbnuts put everything in there. Why he wants to do. I mean, first of all, you got a picture of the guy photographing. He's shooting him. I don't know about you. I don't care if it's a love letter. I don't care if it's a script for a made-for-TV plot. He's shooting him. I don't care what it says. Yep, that's him, all right. And why did he do it? I don't know. Why is he pulling the trigger? Why did he? Okay, good. Also, the question is whether the jurors see him as a politically motivated. Who cares? Politically motivated to take, or wait till they hear the story about this man and the father and the family. Politically motivated to do what? Look, everybody's a little pissed off at the insurance industry, but come on, shut him down like a dog in the street. In fact, we walk by this where he was killed all the time. There's like, I don't think anybody, there's no, plaque or anything there. Anyway, the other thing is whether the defense can fracture chain of custody and forensic credibility. It's worth a shot. And also whether suppression victories create broader reasonable doubt themes. It's worth a shot. See, my book, in my opinion, after you do this, you shot your wad on this, this is going to go to sentencing. Your job is to keep this guy, to minimize this. Maybe he's crazy. Maybe he was under the influence of drugs. Maybe because of his back injury. Maybe whatever. He's crazy. But as far as the actual act of crime itself, it's there's nothing there. And by the way, if you were to try to do something, remember this. If you were to try to advance some kind of insanity defense, you've got to admit you did it. See, it's kind of an affirmative defense. You go, yeah, I did it, but here's why. Oh, you did it. Yeah. Oh, but you were crazy, right? Well, thanks for telling us you did it. Took care of that. So the case has evolved from a straightforward murder prosecution into a constitutional war, maybe over searches and federal overreach, media spectacles, and whether, prosecutors tried to force a terrorism narrative where the facts didn't fully support it. But the bottom line, listen to Grandpa here. Let me tell you, he's done. He's done. He's finished. Now, sentencing, look at the leeway. Remember, this is communist Manhattan. Alvin Bragg, by the way, this is a gun case. So this is the same guy who tried Trump for that stupid Dusty Saddles, whatever that, Stormy Daniels, whatever that stupid thing was. But this guy, there's no defense. There's no defense. I would throw all my emphasis in the sentencing. He's screwed up. I would make you say, you know what, this guy is? He's crazy. He's whacked. He's nuts. He was in some kind of back pain. Good luck. No, I think, no, this is a hit, man. This is a hit. I would say, ladies and gentlemen, you can't really say this, but in my practice, we never have. This is like a serial killer who just started. He had one job. This is a Ted Bundy who was arrested on his first time. He plotted, planned. It doesn't get any more first-degree murder. You don't even see this. I mean, this wasn't somebody he knew. This wasn't some spurn lover. This wasn't an ex-wife who took his kids away. This wasn't somebody who fired him. This is an insurance executive who may or may not have had anything to do with him per se, and no reason. He's independently wealthy. He never suffered any kind of a problem for this. And by the way, and you can't say this, but you're going to say, a lot of us are pissed off at a lot of things. You know what I mean? Cable prices, food. I don't know about you, but every time I go to the store and I get a big bag of chips or something, it's half empty or half full, depending upon where you're from. I don't even know what the hell's going on with that. And I can't stand. And airlines. So I'm going to shoot an airline CEO? Oh, I can find all kinds of reasons for people. Drug companies, forget health. Drug companies, the head of CVS, or I'm just picking Walgreens, or you're aiding and abetting this complicity, and or I can shoot somebody who owns let's say a news company anyway, or somebody who makes golf clubs because golf clubs are associated with Trump and Trump plays golf, and you want to play this? No, you got to tell somebody. We don't want to hear. If you've got a beef against somebody, you do it the old-fashioned way. You complain, you sue, you picket, you do whatever you want. But you don't shoot somebody down. What is this, Dodge City? You shoot somebody down like a dog? What are you, a boy named Sue, shot a man in Reno just to watch him die? This is ridiculous. This man and this family, he didn't have anything to do with it. You don't do this. What is this? We're supposedly this, hey, look at us, woo, woo, woo. Now, compare this guy to Tyler Robinson. Tyler Robinson, there's nothing there. Nothing. You got it? Capiche? Nothing. So what do you think, my friends? I'm going to put some questions for you here. This is a pretty good case, isn't it? Do me a favor. Like this video. Subscribe to the channel. Hit that little bell so you're notified of live streams and new videos. And whatever you do, comment as you see fit.